I'm going to give you my top 7 insider secrets for managing a medical malpractice case. Tip number 1. Before you retain an expert for a file, don't simply just send the medical records out. Get the expert on the phone, talk to them about the case, give them some background, and ask the expert if they think that they can help you with the case. That 5-minute phone call will save you $5,000 because you may find out right off the bat that the expert does not support it or he doesn't have strong feelings either way. So it's a waste of $5,000 or maybe even more than that if you just send out the records without first learning whether the expert believes that they will support the case. So save the money, speak with the expert before you send them the retainer check. That's tip number 1. Tip number 2 for managing a medical malpractice law firm: work in silos. What that means is write down all the stuff that you don't like doing. For example, discovery, motions, intake, medical records retrieval, lien resolution, appeals, probate work, all of that stuff. Divide it into silos and assign one team member at your firm to do each one of those things. Now, if you're a bigger firm, you may need more than one person. But for our firm, there's one person who handles medical records retrieval. There's a young lawyer who does all of our motion work. There's a paralegal who does all of our discovery. We outsource medical records retrieval. The appeals are done by our appellate attorney, and the probate work is also done by a separate attorney who we outsource. We outsource a ton of work, but we divide each aspect of the case into silos, and we assign different people to do different things. What I just described is all the work that I don't enjoy doing. The grind, I call it. And the grind is basically the day-to-day management of cases. I don't enjoy that, so I outsource all of it. So work in silos. Tip number 3, medical malpractice is really expensive. A single case can cost as much as $100,000 or even $200,000. So one of the things that we learned very early on, about a month into our firm's existence, was case expense financing. Because look, 1 or 2 cases, fine, but if you've got 40 or 50 cases and each case is going to run you between $50,000 and $200,000, it's just not manageable. So case expense financing means there is a lender, in our case, Advocate Capital. They're based in Nashville, Tennessee. They advance all of the expenses of our cases. So we don't actually pay for any of the expenses. What this does for us is we basically have virtually unlimited ability to spend when we need to. If we need an expensive accident reconstruction, we don't hesitate to spend it, even if it's going to cost us $20,000 or $30,000, because we know at the end of the day, Advocate Capital has our back. I really recommend that you give this a shot. What this does, frees up a lot of cash flow. We don't sink all of our money into the case expenses, and so we can spend more money on marketing, growing the firm, taking a vacation, what have you. At the end of the case, if the case is won, which hopefully almost all the time it is, then our clients will pay the borrowing cost of the case expense financing. So it's an absolute win for us. I think it's a win for our clients too. That's tip number 3. Tip number 4, be a trial attorney. Push every case as aggressively as you can to trial. You really won't see the real money in a case from a claim adjuster or an insurance company. Real money comes from juries. The insurance companies are all testing you to see, are you willing to take the case to trial? So be a trial attorney. Don't be a settling attorney. Show them that you're real. Not only are you willing to show up in court, but you're willing to take a verdict. And here's the little inside tip. You do that one time, and then the insurance industry across the board will know that you're the real deal. And they'll start settling your cases before trial because they know that you're willing to take the case to verdict. That's so important. Tip number 5, with rare exception, no adjournments of trials for any reason. One year we had 11 confirmed trial dates, and 10 out of the 11 cases the defense tried to adjourn the trial. The excuses were ridiculous. One guy said that his grandmother had sprained his ankle. The defense attorneys will come up with anything because their sole objective in litigation is to delay everything, but most importantly, the trial, because if they can delay the trial, that means that they can delay paying your client money. Now, there's going to be exceptions. The defense attorney's wife died or something like that. Okay, there are exceptions, but with rare exception, never adjourn a trial. Beware the patient portal. Now, as a malpractice attorney, we get records, we verify, we do an original chart review to ensure that we have a complete set of medical records, but we usually don't. And here's the scary part, the patient portal. Especially with primary care physicians, they will have this portal where the doctor is communicating with the patient in the portal, and sometimes in a way that can be very harmful to your case. For example, if the doctor says your test was positive, we need you to see a urologist, please see Dr. Smith on this date. That might not be in the medical records, but it's in the patient portal. The patient portal is so critical. You need to get all of the internal communications between the physician and the patient to find out what was said. Did the patient ignore the doctor's advice? You're not going to know for sure unless you get all of the data from the patient portal. Final tip, when you need to identify who the employer is of a doctor, let's say that your client goes to the emergency room, he treats with Dr. Jones, but you have no idea who Dr. Jones' employer is. And you know, in most malpractice cases, emergency medicine physicians are not employed by the hospital, they're employed by a separate private medical group, but you have no idea who that is. Get the billing records. The billing records will show the name of the employer of the emergency medicine doctor. Then you can sue the doctor, his medical group, and the hospital. The billing records are the best way to identify the employer, especially of a doctor, especially in an emergency medicine case. So those are my secret inside tips from case management of a medical malpractice law firm. I hope you liked it. If you liked it, please comment. Ron, I really appreciate all of your comments. Really means a lot to me, but if anyone comments, I'm going to respond. Please subscribe to our channel. It'd mean an awful lot to us, and I will see you next time.